New York has one of the most tenant-protective breaking lease frameworks in the country, shaped by the Housing Stability and Tenant Protection Act of 2019, extensive case law, and New York City's additional local protections. The governing law includes real property law, real property actions and proceedings law, and for New York City, the Housing Maintenance Code and local tenant protections. If you're a landlord or tenant in New York, the state's strong pro-tenant framework significantly limits what landlords can recover when a tenant breaks a lease. Let's start with the landlord's duty to mitigate damages. New York has a clearly established duty to mitigate confirmed through landmark case law. When a tenant breaks a lease and vacates, the landlord must make reasonable efforts to re-rent the unit. The landlord cannot hold the departing tenant liable for the full remaining rent without making genuine re-rental efforts. New York courts have consistently enforced this duty. The landlord must advertise, show the unit, and accept a qualified replacement tenant. If the landlord fails to make reasonable efforts, the departing tenant's liability is substantially reduced. The departing tenant's liability is limited to rent for the vacancy period plus reasonable re-rental costs, reduced by what the landlord collects or could have collected through reasonable mitigation. Early termination fees in New York must be reasonable. The 2019 Housing Stability and Tenant Protection Act reformed many aspects of New York landlord-tenant law, and the overall direction strongly favors tenant protections. Excessive early termination fees can be challenged. A fee of 1 to 2 months' rent is generally considered reasonable. Larger fees face scrutiny. New York City adds additional complexity. The city's rent stabilization system covers approximately 1 million apartments, and rent-stabilized tenants have specific rights regarding lease renewal and termination. For rent-stabilized units, the landlord's ability to re-rent at a higher rate after a broken lease may be limited by rent stabilization rules. New York's 2019 reforms also limited the security deposit to 1 month's rent statewide, which affects the financial dynamics of broken leases. The landlord's financial cushion is minimal, making the mitigation duty and prompt re-rental even more critical. Military members have the right to break a lease under the SCRA. New York also has state-level military protections that supplement federal law. Fort Drum, home of the 10th Mountain Division near Watertown, generates significant military rental demand and regular SCRA terminations. New York has enacted protections for victims of domestic violence that allow early lease termination. Under Real Property Law Section 227(c), a tenant who is a victim of domestic violence can terminate the lease by providing written notice and documentation, including a valid order of protection or a police report. The tenant must provide at least 30 days' notice. The tenant is responsible for rent through the termination date, but not the remaining term. The landlord cannot charge an early termination fee. Tenants in New York may break a lease if the landlord fails to maintain habitable conditions. New York has one of the strongest implied warranties of habitability in the country, codified in Real Property Law Section 235(b). If the landlord fails to maintain the premises in a habitable condition, the tenant has extensive remedies, including lease termination. New York City's housing code is enforced by the Department of Housing Preservation and Development, which actively inspects properties and issues violations. From a practical standpoint, New York has an enormous and complex rental market. New York City, where roughly 2/3 of residents are renters, has extremely strong demand in most neighborhoods. When a tenant breaks a lease in Manhattan, Brooklyn, or Queens, the landlord can often re-rent quickly, often within 2 to 4 weeks. The departing tenant's financial exposure is typically limited. The NYC suburbs, Westchester, Nassau, Suffolk, have strong markets. Buffalo, Rochester, Syracuse, and Albany have more moderate markets, where re-rental may take slightly longer. The Hudson Valley has strengthened as remote work has allowed NYC workers to live further from the city. One best practice for New York landlords, given the 1-month deposit cap and strong mitigation duty, begin re-rental efforts immediately when a tenant provides notice. Every day of delay is a day you likely cannot charge to the departing tenant. Document all efforts meticulously. Another best practice for NYC landlords with rent-stabilized units: understand how stabilization rules affect re-rental after a broken lease. The interaction between vacancy increases, preferential rent provisions, and the 2019 reforms requires careful attention. New York requires landlords to return the security deposit within 14 days of the tenant vacating. The deposit is limited to 1 month's rent. The landlord must provide an itemized statement of any deductions. These rules apply whether the departure is a normal move-out or a broken lease. For the complete guide to New York breaking lease laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Breaking Lease Law series.